Thank goodness the chair is on point today. She gave me that look and I knew we better get after it. Have you guys used this new system? I think you have, haven't you? Or am I just making that up? Okay, good. Okay.
Yeah.
The red is actually, that means go. It's kind of opposite. Usually it was green in the past, but if it's red and solid, then you're good to go. If it's blinking, yes, it's very logical, isn't it? Yeah, very intuitive. Right. If it's blinking green at you, it's trying. There's probably too many mics on. So at that point, just hit your mic and it'll turn it off, and then you won't have that feedback. So just as you get done speaking, go ahead and turn your mic off. Yep. All right. Well, Chair, I think we can call this one to order if you're ready.
Okay. I call to order the Board of Architectural and Engineering Examiners meeting. And
all right, we'll read the notice of meeting and then we'll just get after the roll call then. We'll just do the roll call first then, since that's first in line. Melanie Doss.
Here.
Blair Parker.
Here.
Rick Thompson.
Here.
Frank Waxter. Frank Waxter. Oh, sorry. Well, he's here. We see you, so we know he's there. All right. Jeff Nally. Dr. Ash.
Here.
Jason Carter. Rob Barrick. Brian Tibbs. Alton Heathcote.
I am right here.
All right. Eddie Jett.
Here.
James Collins.
Here.
All right, Chair, we do have quorums, so we'll proceed with the notice of meeting. The notice of the June 6, 2024 meeting of the Board of Architectural and Engineering Examiners was posted to the Board of Architectural and Engineering Examiners website on July 5th, 2023. The following agenda was posted May 30th, 2024. All right. Unless anyone else has any announcements, I don't have anything under announcements except to say, well, I guess there's a couple things we probably should point out. One, we've got Laura Martin. She's stepping in for Stuart. Stuart, he's no longer with the apartment, but probably moving on to bigger and better things or other things. And so, we're at this point, she's going to take good care of us. She's worked with Land Surveyor Board and some other boards prior to being promoted to Chief Counsel. So she'll be doing the legal report and helping us out and pitching in there. Other than that, and we also, just for housekeeping, of course, we have our training seminar at 1 o'clock, and then we have lunch upstairs for you guys at prior to that. So we'll just keep things moving on and then get you there. All right. Also, as a result of the staffing change, you may see a couple other faces filling that slot until we get a permanent candidate. And so, but you won't see any disruption in the business. We'll keep tracking on and taking care of that. And also, we may get that rulemaking hearing that we initially thought was happening in August, will probably get delayed. I suspect we just want to get our folks sort of settled in and handling the report without trying to shift to a rulemaking hearing as well. It could pop up and be able to do it in August, but realistically, we'll just need to track that and we'll see where that goes. All right. The agenda then. Any edits to the agenda? And then, Chair, I'll let you just sort of collect all the votes on those as we go through the items.
Does anyone have any modifications to the agenda? So do we have a motion to accept the agenda as presented?
So moved.
Second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
All right. And just for a notation, that looks like the motion was Rick Thompson, second, Blair Parker. Okay. Okay. Thank you. April minutes.
Do we have any discussion regarding the April minutes? Any corrections, modifications? Need a motion to accept the minutes as approved?
So moved.
Second?
Second.
All in favor?
Aye.
All opposed? Motion carries.
Blair Parker's got me trained to look at him now when we get to the minutes because he's my editor. All right. Professional society reports. All right. Do we have anyone from engineers? Casey Anderson. Let me just take a look. No, she's all right. Is she online? No? Okay. We had Ray Tant, he gave one of our updates here recently. In his stead will be Suzanne. So Suzanne, if you would.
Not trained on this.
Okay.
Thank you. Excellent. Hi, I'm Suzanne Herron, and I am president of the Tennessee section of ASCE, American Society of Civil Engineers. We have over 25 members statewide, 5 branches, and 11 student chapters. I'm sure y'all are familiar with the group. So we have been partnering with ACEC for the fall meeting that they have, and we present a student session at the meeting. So we've been doing that for several years, and we're continuing to do that this year. We invite students from the universities across the state and have a half-day session with them. That's usually a lot of fun. At the last meeting here, Ray Tant mentioned that we had several student chapters going to a regional competition that was held at UT Martin. And 3 universities from Tennessee won in that competition and are going to national competitions. One university is Christian Brothers, and they won for the steel, or they actually came in second for the Steel Bridge competition. So congratulations to them. UT Knoxville came in first for survey. Congratulations to them as well. And Lipscomb won for the concrete canoe competition. So Lipscomb now has the challenge of trailering a concrete canoe to the national competition in Utah. So good luck to them. So the universities are the Tennessee section of ASCE has given these 3 universities financial donations to help them out with their travel to the national competition, but they are welcoming additional, contributions as well. So just throwing that out there for them. But that is it. That is all I've got. So any questions or anything?
All right. Thank you,
Thank
Suzanne.
you.
Appreciate
Yeah, I
it.
don't have any questions. I would just like to say thank you for bringing such good news to us. That's just fantastic that three schools in the state are placing in all these different competitions. That's just awesome.
Also, please congratulate David Elrod. I don't think that's the first time they've won the concrete canoe competition. So Lipscomb's doing something really, really fun over there.
Yes, thank you.
Maybe they need to put a production line of concrete canoes. Would you buy one, you think? You'd be the only guy on the lake with one. How did I say that?
You know, I'd worry about showing off, lifting it to put it in the water.
True. Good point, All right. Looks like, let's see if Ashley Cates is here online. Is she online? Okay. Looks like Ashley Cates is there. Oh, part of that would probably be because they're in conference. That would probably be why she would not be online. All right. So then we can move on then to Nathan Ridley. Let's see. I didn't see him back there. No. Yeah. All right. Looks like we're ready for the our interior design then. Tiffany.
I want to congratulate the interior designers for actually being here and present.
All right. Well, I'm Hannah with ASID. I'm the current president-elect, incoming president as of October, and representing for the ASID Tennessee chapter. Oh, sorry, I've got a little vertically challenged here. I'll go through some updates. There's a lot going on right now, so bear with me, but I'll try to be as quick as possible so we can get to the other societies. So our national meeting gather is slated for August the 11th through the 13th in Denver, Colorado. And Nationals has announced that this will be geared more towards our leadership training for the board this year, which has been a big recommendation from all chapters just to get more leadership training for their roles. And then every other year that will happen. So we'll have more of just a gathering of all designers every other year. And then the in-between years will be our board leadership training. So that will happen this year in Denver. We also attended the National Advocacy Chapter Leader Meeting that happens pretty regularly, about every month, to discuss legislative updates throughout the states. And then this past meeting, they did ask for members of each chapter to attend the upcoming Day on the Hill in DC. This is the first time that they've verbally come out and asked us to be present. So we're waiting to hear more details if we will be present as Tennessee. It's not something that we had budgeted for. So we'll see what we can do there, but we're hoping to have at least one or two present there. Nominations are complete for the new board, and that should be announced probably this week, and that's slated for the 2024 through 25 year, and those will begin their term in October 1st. Just a few different meetings that are going on. Our second annual outdoor living event is next Thursday at the Kravitz Showroom in Nashville Design Collective with a CEU and designer panel. That was a really successful event last year, so we're going to try to continue it every year here. District meetings are actually officially on summer break until we start back up in August. So our next event is just tying into an existing post-Neocon sort of event that's hosted by J&J Interiors, and that's called Inspire Nashville. So we wanted to do something with the students since they're on summer break right now. So we're doing a joint meeting with NKBA. It's a student-focused kind of pre-event lunch at ORI. With a steel case presentation and panel discussion following with just a variety of industry professionals, getting them ready for the next upcoming year. And then we'll head to the fairgrounds for Inspire, and we're giving students some prizes, depending on how many booths they're able to visit. And we're kind of assigning different members to take students around and really introduce them to their industry partners. So hopefully that will be a successful event and possibly something annually we can do. Our industry partner appreciation party that happens every year, that'll happen at T-Line Nashville from 5 to 7 on June 27th. And obviously free for industry partners, but anyone can come join us. I think it's about $25 just to join and have fun and I believe play some putt-putt. And then our annual strategic planning meeting that happens every year, that's in August 23rd, this time in Chattanooga, just to visit some of our other districts. And this is where we set the budget and our overall goals for the coming year. So that's a really big date for us. And then the next biggest event, the state conference, that is September 19th at 1410. Again, we're still in some planning stages, but we have officially set a dinner with CEU keynote, and we're doing a tablescape competition this year. That's going to be comprised of teams of designers, students, and industry partners. So since we're kind of off on our design awards year, we wanted to do something fun and different and get everyone involved. And I'll hand it over to IADA.
Hi, I'm Tiffany Clegg. I am VP of Advocacy for IADA, and I have a special guest with me today. We are hosting a student, and she wanted to introduce herself.
Hi, I'm A&E. I'm from the University of Arkansas, so I'm an intern at Tiffany's firm, so I'm excited to be here.
Okay, so the joint ASID and IADA.
Wait a minute, she's got to say Sue-wee.
Some updates from our joint ASID and IADA efforts are we have met locally to discuss both a national coalition and the possibility of a local coalition between IADA and ASID. So we're hoping to kind of collaborate a little bit more and working on a networking opportunity that we're thinking is in the form of a happy hour that would be with all industry professionals, including architects and engineers, looking at around the October timeframe. So more details to come on that. For IADA specifically, we met with Amber Adams, an IADA or an AIA Middle Tennessee's EP committee member, to discuss potential opportunities for our organizations to collaborate on events in the future. So more to come on that. The summer chapter leadership council meeting is this weekend in Chicago, where we will focus on student engagement specifically. For the IADA's National Annual Meeting Awards Gala, that will be held also in Chicago on Sunday, 6/9. NeoCon and Design Days will be happening also in Chicago from 6:10 to 6:12, so a very busy weekend there. 6:26, the IIDA will host an informal informational NCIDQ webinar, the Q and U. The sessions will focus on how to include NCIDQ in your career path and the benefits of certification. On 6/7, we will hold our annual sponsor thank you event at Mercados in Wedgwood, Houston. And in July, we are going to have lots of statewide CEU opportunities and midsummer student interns and a professional mixer. And that's it.
Any questions on the interior design report?
I have a question.
We just need your mic. There you go.
Is that it? Okay.
Yeah.
Yeah, red is turned on.
Yeah.
Thank you. You know Marlon, don't you? Blackwell? Yeah, yeah. We were classmates at Auburn, so
Yeah, he's a perfect.
I'll get with you later and share some things.
Small world.
Thank you.
All right, thank you.
He probably felt like you were outside of his reach by sending her over here to Tennessee, and still you found him. So that's all right. All right. Thank you, ladies. Okay, looks like we're ready then for the director's report. So we'll hit the budget report, which is more information only, no action there. If you have any questions that hopefully I can answer. If not, then I'll of course get back to you per usual. Let me just give you sort of the rundown. I try to always hit the highlights first, give you the big picture, and then anything that I saw that just stood out to me. At the last meeting, we reviewed finance reporting through January. So we currently have 3 more months of records. So we're primarily looking at February through April. For February, you'll see a large expenditure for grants, for grant awards under other expense line item. Pretty typical. The contracts go out and those checks get cut in February. So that's pretty consistent with every single year that we do this and then continue to do that. So resulting in that month's deficit. So that's also typical. You cut a $400,000 check, in 1 month, you're going to have a deficit. So, but nothing that we haven't anticipated. Let's see. We also saw in February a reallocation back to salary and benefits line item due from a CSE charge in August and September. So there's a reallocation there. So you'll see a little, you'll see that represented. For March, there was a little over 11,000 reallocated to the technology expense line item from data processing network services. So that's, I'm just digging in that one a little bit more, waiting to hear back from them. I saw the line item. It's data processing network services, but that doesn't give me the meat of what I'm looking for. I mean, we got to have a sense of that. It's probably a reallocation, but if there's anything out there that after I hear back from fiscal on that, I'll report back if there's anything that need to be aware of. But that's the only things that jumped out at me on that seemed irregular or regular, but you still have to speak to a $400,000 line item, so just kind of a good reminder. But other than that, I didn't see anything else that jumped out at me. We're still in surplus tracking. For this year, looks like $212,000 in surplus for the operational budget for the year. Any questions on that or anything that jumped out at you? Okay, then I think we can move on to the Tennessee Engineers Conference. That is September 29th through October 1st in Franklin, Tennessee. And in essence, we just need approval for all the engineers to attend and speak. Casey brought that up last time. And we you of course remember that last year. There'll probably be a round table, something to that effect, and she'll kind of hammer out the details probably at the next meeting or prior to a meeting in September. But we just need approval for travel to that and for them to speak on our behalf.
So moved.
All right, thank you, Blair.
Second.
Got a motion from Mr. Parker, second from Mr. Waxter. All in favor, please say aye.
Aye.
Any opposed? All right. Looks like that one passed then.
Glenn, since we don't have engineering committee meetings anymore, or not often anyway, do we know who from the engineering side is? I know I will be there. And usually Ash is there. Eddie,
I'll be there.
James, are you going to be there?
Yeah.
Okay, we'll check with Rob also and find out.
And I should have I failed to mention it, but I should have in announcements, primarily since Rob was absent today. But he is, of course, we have several expirations, and they're still working on the reappointments, and so we'll get some news here hopefully pretty soon for everyone. Rob was the only one that was going to roll off. I think he to his point said, "Hey, I just want to go play golf," and that's okay. He's earned the right to do that, and so we're going to let him do that. So. We'll get a replacement for him and looking at some candidates now. So that may be a process, but Rob has been he's been very kind and gracious, and to help with quorum is offered to stay on until we find a replacement for him. But he'll be moving on shortly, and of course we'll bring him back like we have with some of our other board members and honor his service as well. But today he had a scheduling conflict, so I suspect he'll be back at the next meeting, or unless we get another replacement, and then at another appointed time. All right.
Glenn,
Yes, ma'am.
Rob was the next chairperson. So
I think that's why he's doing it in protest. Right.
So do we need to?
I don't think so. I mean, if we could do that, obviously, certainly if there was thoughts about that, and that would be welcome. We can do that the next meeting, or even this meeting is fine if someone had a motion in regard. Or you can just follow the sequence that you normally, and then Blair would just be bumped up. So then we'd be looking for a secretary in essence. Yeah.
Wouldn't in the protocol, I'll defer to Rick because I know he's been involved in this a long time and on the nominations committee, but don't we usually defer that back to the nominations committee and reestablish a list of candidates? It would be obvious to have everybody else in the procession step forward one step.
Yeah, I think we should have some conversation about that. No offense, but yeah. He is a landscape architect after a while. No.
Yeah.
No, but we should probably discuss it a little more.
Okay, sure.
Yeah.
We'll put that in the next next meeting. We'll just have the committee for that. Okay.
And I agree. I think it should go back to committee because there's a sequence that we have loosely followed in the past, and I don't know if we want to break that or not.
Well,
But
it's not absolutely necessary that we do it, but I think if we're not going to do it, we should have that discussion.
Sure.
And if we ask if we could have the meeting at the clubhouse at the golf course next?
Yeah, exactly. He's not getting away from us.
No,
is
he's
he?
not going to get away with this.
Yeah.
I mean, he has to buy lunch. And
Yeah, I tell you.
we're good.
And now it's in committee. I mean, Blair, they foiled your plan. You know what I mean? You were on the rise, but too late for that now. All right, so we'll do a nominations committee meeting then prior to our meeting. I guess let's see, August. Yeah. All right. Let me write that down. Okay. All right, then I think we're ready to move on to NCWS Southern Zone meeting update. James Collins, and so there's a couple folks that were there, of course, James Carter and James Collins, James Squared, as we affectionately call them, were in attendance. And so I'll let James sort of fill in any details if he likes, or if you had something you had already prepared, then take off. Okay. James Collins sat on the Committee on Examination Policy and Procedures. That's kind of a mouthful, and that's not for the faint of heart, as you know. I mean, I typically, when I hear policy and procedures, I run in the other direction, but he dug into that work, and we appreciate you doing that. And being relatively new to the board, for already be, taking that on, that we appreciate you doing that and serving that capacity. And he provided updates to the entire zone at the meeting. Jason Carter, he sat on the very prestigious Resolutions Committee, and provide a very important update to entire zone as well as the end of the meeting. And basically, I really thought the Resolutions Committee was going to be some sort of heavy hitting committee, and then they get up there and it was basically a conference roast. You know what I mean? So it was funny and entertaining, but he's got that sort of dry sense of humor. He really will sell it, like it's the gospel, but so anyway, that was fun. But he did technically serve on a committee. So it is sanctioned by NCWS. So we appreciate Jason Carter, and I told him that I would probably kind of fill that out a little bit, and he can just correct me whatever I said in August. So we'll let him do that. in the future, I look forward to learning more about the important work, they're going to continue to do in Resolutions Committee. We'll see where that goes. Jay Kaufman, I know they're in land surveyor world, but nonetheless, they are part of NCWS. He chaired the nominations committee, and Team Lingerfeld did the surveying and mapping sciences licensure task force. And so, I mean, Tennessee was well represented in that meeting. They were doing a lot of work, and I kept every single time they were doing an update, I just kept seeing our guys from our table going in that direction. So I was impressed by that and appreciate that work. And thank you for representing us. Did you have anything else that you wanted to add to that?
Yeah, I was just going to add that some of y'all may have seen the email from NCES recently about all the resolutions that'll be up at the August national meeting. Most of those resolutions are really just kind of cleanup stuff. Like in the NCES law right now, there's all kinds of different references to what an exam is. Something's called, an exam, a session, just like all kinds of different names. So it's a lot of cleanup work really just to kind of get all that so it's consistent. So when somebody's looking at the NCES rules, they can clearly understand what we're talking about when we talk about that. There was a real good discussion about the UK agreement that we'll talk about in a few minutes. There was a lot of good discussion about that. Very impressive what that group has done. And the other thing I was going to mention is, this is something that we've talked about a couple of times since I've been on the board, but there is a recognition by at least the membership, not necessarily NCES, but by the membership, that the PE exam is not really accomplishing everything we'd like for it to anymore because of decoupling and the way that the exam is structured. So there is an effort, there's a committee that's been formed to look at things that boards like ours should consider when reviewing applications for PEs. Looking at type of experience that they have, their communication skills, all kinds of things like that should be considered. And I think one of the recommendations that may come out of that is maybe a change to the applications to include information about some of those items that should be included in the application to help show that that person has gained the skills, knowledge, and experience necessary in order to be a professional engineer. So I think that's a welcome change for a lot of us because of the way that the exam has become really more academic and not so much based off of practice anymore.
Good deal. All right. Thank you, James. I appreciate that thoughtful and response and digging into some of those nuances. Every once in a while you have to do sort of a cleanup to the rules, and I appreciate that they're doing that. There's lots happened in the industry, and so it's probably due. So I'm glad they're doing that. Okay, let's see when any other comments. I think we're free to move on to the UK mutual agreement. I just sort of had an introductory to that, and then I think Dr. Ash will maybe provide a little bit of a primer. I think you had some points that you wanted to just point out to that. We don't have to, obviously, we don't have the full contract per se in front of us. It'll go through its customary review. I mean, we'll dice it up, and I think Dr. Ash sort of did a preliminary run at that, and I appreciate you digging into that a little bit already, and we'll all get a chance to do that some more. The engineers have had it in their hands for about a month. I wanted them to, when I had it, for them to be able to sort of get into it a little bit, and we'll do some more of that probably in committee as well. I don't know that there's anything necessarily decided right at this point, but we do at the conference, they want to do a sort of a ceremonial signing, just for those that have an intent, to continue the process. It's not a contract. It's not intended. It's more like, NFL or college draft day, or like the lottery. You get the big check, but you wouldn't take that to the bank in the drive-through. You know what I mean? Same with, NFL. They give you the shirt, but, that's not, the contract is what matters. And so we're, of course, Eddie, myself, Mr. Carter, and James will be there as well. So they can only have, I believe, 2 people on the stage representing each jurisdiction with intent to sign that. They've got quite a few jurisdictions already, so there'll be quite a few folks up there. But really, the purpose for this line item is just to approve that ceremonial signing. And then because James and also Jason Carter serve on committees, it seemed logical to have them as our two. And then, of course, Eddie Heckling, and plus he's just good at it, so we just need him out there. But if and then if it's okay, before we do that, if Dr. Ash, if you just want to maybe point out some of those highlights that you saw when you were going through that agreement.
Yes, and we actually, James and I, and we will all discuss that a little bit before the meeting and what James have seen and heard during the Southern Zone regarding the discussion for this particular item. And first, that 200-page document should have been like no more than 50 pages.
Yeah.
There is a lot of fluff in there that could have come out.
Yeah.
But just going through the vetting process that the UK has, I was leaning towards that it's actually more stringent than what we have here. I like the concept that the candidates have to go through an interview before they actually accredit or given a certain label. I like the idea that they have accreditation for engineering technicians, which I don't think we have something similar to that. The process is different, but to some extent similar and more stringent. And so, as a summary, I think it would be something good to agree to. I didn't see any deficiencies in their system compared to ours.
Thank you for that. I appreciate the commentary and you doing that preliminary review for us too, as a primer. One of the things they reminded us is that we're looking at minimal competency. We're not looking for an exact replica of our model because obviously different jurisdictions will handle those differently. But how do they get to that competency? That was the main gist or driver that we were focused on. And I appreciate you doing some of that legwork. And then, of course, we'll all get a chance to dig in a little bit more in committee, and then we'll decide from there. And if they, signing it or whatever associations decide on is still different than it getting approved here, in our jurisdiction too. Oftentimes, and it'll have to go through all of the reviews. And so I look forward to that process. It won't be quick, and it shouldn't be. Those things have to be sort of, slow and deliberate and thoughtful. So that way we're comfortable with what we're entering into. But I look forward to it. I think that's I think that's exciting, just to be able to go to Britain and be able to work there as well. That would be kind of a neat little thing, So, Big Ben needs a updo, then maybe, you could be a part of that. So, all right. I guess then we'll back to the ceremonial signing. We'll just need a motion to let Mr. Collins and Mr. Carter for the ceremonial signing.
So move.
Second,
Second.
all in favor?
Aye.
Opposed? Motion carries.
All right. Jason's excited too. He's already got a periwig and like a robe, and I mean, he's pumped. It's going to be good. All right. And James, make sure you get really good pictures. I'd love to, and we'll bring it back to you. All right. Looks like we're ready then for the public comment period related to items on the agenda. Let me just take a look and see if anyone's signed in. Then also, and while I'm doing that, Alex Griffey will look online and see if anyone's signed in there with the intent to do that as well. Okay. All right. Looks like it's all association folks. Let me just open it to the floor, see if there's anyone else. Anyone? All right. Seeing none. Anyone online? All right. None. Then it looks like we're ready to move on to the legal section and the legal report. And then Miss Martin, she's going to be in the driver's seat for that one, and we'll take it from there. It looks like we're for number 1.
Good morning. I just wanted to introduce myself again. My name is Laura Martin. Probably most of you don't recognize me. That's fine. I have been with the department for a lot of years, and I am chief counsel with the regulatory boards. And although I was never assigned this board specifically as a staff attorney, I have been involved with your program quite a bit over the years. So I don't want you to think that I'm stepping in without any knowledge of your program. We have the legal report in front of you. I had to amend a couple last minute, which is why you got that second email to review. So I'm happy to go through this however you prefer. Do you guys usually just ask the questions, or how do you want to
normally Stuart reads the entire thing and we go through and have a recommendation
He
for
reads the whole, like the,
every word.
okay, I can do that.
And that was Stewart, so.
I can do that. Okay. So, right. The first case on the legal report, complaint number 202-400-5021. This is an architecture case. Complaint alleges that respondent, a professionally licensed architect, was a former employee of the complainant, a firm named for a professionally licensed architect who is apparently since deceased. While employed with the complainant, the respondent was involved in multiple aspects of the business and participated in the design and preparation of numerous instruments of service. Complainant alleges that on or about December 1st, 2021, after respondent's resignation from employment with the complainant, respondent filed articles of organization under a new firm name with the respondent's name with the Tennessee Secretary of State. Respondent continued through the new firm to communicate and work with developers and owners on many of the same projects in which complainant firm served as architect of record. Respondent claims that the intellectual property in question was jointly owned by both complainant and respondent's firms. They claim the shared ownership arose from a collaborative relationship between the entities, and the intellectual property was originally created by respondent for use within their venture, and that the access complainant had to this information was solely due to their past association. Respondent claims that following the death of the architect for whom the complainant firm is named for, the surviving family members sought to assert ownership rights, seemingly unaware of the pre-existing agreements between respondent and deceased architect. Without documentation of respondent's claim that this sharing of intellectual property was agreed upon by both parties, the board has authority to discipline the respondent for misconduct claims, including modifications made to another architect's drawings or specifications improperly, for misrepresenting to the client who the respondent's associations are, since the work was accepted under complainant's firm but was continued through respondent's firm. And representing about 12-ish projects on respondent's website with unconditional credit when complainant firm was at one point the architect of record for such projects. The complainant's attorney has notified that they're considering civil litigation since many of these alleged wrongdoings, of the respondent are not within the purview of the board. However, at this time, no formal proceedings have been filed. So my recommendation here was discuss, just because there is a lot of complicating factors in this. So like I said, there is an attorney representing the complainant firm. And if civil litigation goes forward, it's pretty unlikely that a respondent would sign a consent order or a settlement agreement. But the respondent has claimed that all of this was agreed upon. But of course, the person who the respondent made those agreements with is deceased. So without I have been provided no evidence to suggest that that agreement was ever reduced to writing or emails or text messages. So the board does have authority outside of civil litigation, but that's just kind of a factor that I wanted to put out there for you guys to discuss. So our options are to either go forward with some discipline or to consider putting this in a litigation monitoring status and wait and see how civil litigation plays out.
Jeff, thanks.
Sorry. Would there be any impact on the civil side of any decision made by this board?
Sure. If the board made this decision, that would absolutely be something that either side would probably attempt to use or have precluded, depending on the party, in court. So, which is often why if something's in litigation monitoring, our chances of settling a case are going to be lower. Because if you are going to be in civil court, you don't want a document out there that you signed admitting to wrongdoing. But that doesn't preclude this board's authority if they still wanted to go forward.
I have a question.
Sure.
On the opposite side of his question, does us not taking any not requiring any consequence to this guy have an effect on the civil litigation?
Well, it could, but if we were to put it in litigation monitoring, basically what we're saying is we're not taking action yet. We're waiting until civil litigation moves through. If we were to close the complaint with no discipline, then that probably would be used in civil litigation. But I'm not suggesting we close this complaint.
Yeah, would it be proper for us to keep the complaint open until we find out the result of the civil litigation?
So that is what
And then-
litigation monitoring status would be. We would keep it open.
Okay.
Basically, we're putting it on a shelf, but we would try to get regular updates from the attorneys. I think it's unlikely that they don't go forward, but like I said, nothing, as far as I did call them this week to verify. And as far as I can tell, nothing has been filed yet.
Okay, then I'd like to move that we continue to monitor this case.
Excuse me, Frank, I would like to make some comments before we make a motion since I reviewed the case.
Okay, we have a motion, but no second yet.
Do we have a second? All right, okay. Well, first of all, I disagree with that. No one has reviewed the case yet but me. There are multiple other items that could possibly be rule violations. I don't want to talk about it in length or give too much information, but this is a very serious issue here. If you take someone else's work, that's an architect of record, and you do the things that are represented just on these two rules here, that's grounds for discipline and possibly severe discipline. And then if the other items are correct as well, if we don't look into this I don't want to put it on hold. I want to pursue this because I think it's urgent. We have no idea if it'll ever get to civil litigation. So we could be here 2 years from now trying to figure out, I wonder what happened to that. So I prefer that we move forward with this. And if we get if we get the, I guess the defendant or whoever the gentleman is, it's the
For us,
complaint.
it's a respondent,
Respondent.
but in civil court, it would be a defendant. Yeah.
Okay, so the respondent, but also it states that there are multiple people involved in this, not just the respondent. And if there are multiple licensed architects that have participated in this endeavor, then it's not just the one person. It's multiple people who may have committed fraud or may have done something illegal. And when I read through it, it was very disturbing to see that someone may have done this in the profession. And I have personally had people that were trying to represent when they left my firm that they had projects that they had done on their website, and we had to get that resolved. So this is not uncommon, but this is a lot more than I've ever seen in any kind of complaint. So I would appreciate it if we don't approve that motion and move forward with a different motion to go ahead and continue investigating this. If we get someone's attention, there might be, well, I'll leave it at that. I think we should move forward with a complaint.
Well, let's vote it down then.
I agree. I've witnessed a few of these instances. I think there's a couple other cases on the docket that are similar, but with the top labor markets and senior people moving around and the representation of projects moving through proposals, and there's a lot of gray area and rule bending. I agree. I think we should address it. And
is there a chance that this will settle out of court? So we also waiting for result in.
There's always a chance, and Mr. Thompson isn't wrong. Civil litigation takes, it's lengthy. It takes a long time. You see how long it is for our cases to move through. And believe it or not, we have a lot less red tape than they do. And like I said, the board's authority to impose discipline does not hinge on the civil court. So it is within your purview if you would like to go forward, and we can talk about, an appropriate civil penalty or other discipline. if that's the way the board wanted to go. And yeah, this was just sort of a complicated case that I thought had a lot of moving pieces. And so I did want to prompt a discussion as opposed to me just making a recommendation on something that I didn't have as much familiarity with.
Madam Chair. Hello. I think we have a duty and obligation as a board to enforce our laws and rules, regardless of whether there's a civil case involved. And I would agree with Rick that we have an obligation to protect the integrity and character of this profession, our professions, by actively pursuing this. Rick, did you have a recommendation?
Well, it's a little background.
We just need your mic there. Sorry about that.
Push the button.
As some background, when Stuart and I had discussed this on a couple of occasions, I was still in the review process of trying to sift through what the complaint was, and the point that Laura made earlier is that there so far there doesn't appear to be any type of formal document that gives these this architect or anyone else permission to use the other architect's work. And if that is the case, then that may change some options that we may have. But so far that has not been submitted. It's just a verbal, oh, we had an agreement. So, that's about as good as they've got right now, as far as I can tell. So now with Stuart out of the picture and Laura is in the picture, I would like to have a little more time to come back to the board at the next meeting with a formal recommendation after we've had a chance to discuss it, because as it stands now, this is basically the summary of the case. And that's why I wanted to keep it open so I could pursue a little more in regard to how many of those line items are actually apply to this complaint, and then come back to you if it's the 2 that we have or the 3 that we have here, or is it the 8 that are on the complaint, or however many are on the complaint. I think that'd be
right. I mean, so I put that in there sort of as a general. I wasn't intending for that to be
right.
Right. For instance, if they're representing 12 projects, that's really more than one violation, right? I was just trying to give you guys a general idea of really what the authority here is. Because some of this is, so the argument for, which I'm just putting it out there for consideration, even though I can see that we're probably not going to go this route. The argument for litigation monitoring status is sometimes it is better to let the parties hash out some of the evidence and some of that stuff in an arena where they're going to have more resources. And additionally, I just want to, make sure that we're really keeping separate here what is not in the purview of the board, which would be in the purview of civil courts. Representing your work, representing someone else's work as your own work is obviously in the purview of the board, but we're not looking at trade secrets. We're not talking about like intellectual property. Those are not things that we would oversee. So that is sometimes why people put it in litigation monitoring. But I just wanted the board to understand that even outside of all of that, this board still has authority, at least under these 2 roles and probably a few additional ones.
And understand that, and thank you for putting this together like that, because it just gives the board an opportunity to see how across the board this is a problem. And thank you for saying that someone may or may not understand that they're not allowed to do that unless maybe they have a written agreement or something to that effect. So if it's still open and I can come back to you, that's what I'm asking. And then if at that point the board decides to wait for the civil to happen, then that's one thing. Or we can take action if there are violations, serious violations. So thank
Yeah,
you.
Rick, I think my motion was to continue to monitor this, not do away with it.
Well, the way
I think that's what your suggestion is.
well, no, the way I understood the monitoring was that we weren't going to do anything and we were just going to wait to litigation. If that's not the case, then that's different.
We'd monitor till something new comes up.
Well, something new could come up at the next meeting when I make a
I
recommendation.
know, that's what I'm talking about.
Yeah.
Well, we do have a,
Yeah.
Uh,
Somebody's got to turn off their mic.
all right. Since we have a motion on the floor, which is wholly appropriate, typically you put a motion on the floor based on what's perceived as a recommendation. So that was good. And then we'll have the discussion, and then out of that discussion, people made this kind of move, it moves the needle one way or the other. And that's kind of what happened here. And so that's good. That's healthy. That's robust. But the dispatch of the motion will either need to withdraw that motion and then make a new one or vote on the one we have on the floor. So, yes,
For
sir.
clarification, if we vote positive for the motion on the floor
Mhm.
and we're basically holding off, does that also take legal's time away from questions that he may have as he goes through this review?
No, we can, so from what, if I understand Mr. Waxter's recommendation to put it in a monitoring status, we could do that. And then if the board's preference is that we bring this back again at the next meeting, after me and Mr. Thompson have a chance to maybe discuss this case more thoroughly, we can do that. All it does is put it into a holding pattern, which would give us more time. So at the next meeting, we could determine we don't want to hear this again. The board could say, we don't want to hear about this case again until the civil litigation has concluded. Or you could say, no, we've had some more time. It doesn't seem like, who knows what will happen between now and then, and here's how we want to move forward. So it does not preclude legal from working on this case, if that's something that you would like.
I would like to ask if litigation monitoring is the appropriate term that we should use, or if you should amend your motion with a different term, because litigation monitoring means it's a legal term. Right now, we are just wanting to collect more information before we make a position as a board.
Let me do this. I move that I will withdraw the motion if the second is willing to withdraw the second.
Who was the second? Okay, withdrawn. Is there a new motion?
Okay, is there a new motion?
I do think, because you'd mentioned there's a lot more here. I'd definitely like to hear more information about it, see what you can find out. Was this guy billing? What proof is there that there was some sort of agreement? Sounds like there wasn't any other than just maybe a handshake or a nod. So I'd definitely like to hear more information, and I think it's appropriate to give you more time so that you can come back to the board and say, here's everything we know, whether it's bulleted list or whatever, and then we can decide at that point. So.
Is that a motion?
Yeah. Yeah, I think the motion would be to continue to investigate. I don't know if that's appropriate title for it, but.
Well, I have a question, Rick. Are we ready on this item? Are we ready to move forward with moving on the two rules that are said to be violated in this? Or are there other violations we need to look at? Sounds like there may be.
That's the point, Frank. There are multiple claims, and these are certainly realistic claims that I think that are valid. But if you, and again, I don't want to give you any more information. other than there are multiple ones that I have not had a chance to actually vet through because Stuart and I were talking about this stuff.
Oh,
And
okay.
so if we could, well, I don't know what the term is.
I think what we can do, what we were discussing a little bit, I think we kind of all want to do the same thing, and let me know if I'm wrong. Basically, we're putting it in litigation monitoring right now as a stopgap, so that way, in case something develops before we represent at the next meeting, so we're doing both. We could do that. We could put it in litigation monitoring today as a motion with the possibility of representing, giving you the chance to represent it at the next meeting in August. And then that way, that's 2 months, where at least it's a stopgap. It's something develops, litigation monitoring in the next 2 months. Probably not, but it could. And so we're doing our due diligence, and we can do both.
So, so that is, what Frank's motion was, but
He withdrew. I think it sort of was, but just with the caveat that we intend to represent. So
Okay.
it's sort of the same thing, but we're just expounding on that, saying it's a litigation monitoring, but that's not all we're doing,
Yeah.
And so it's
Yes.
litigation monitoring until we represent.
okay. You
Yeah.
want to restate, do a new motion, propose. Yeah.
Yeah, my motion is what he said.
All right, so basically what we're just going to put it in litigation monitoring until we represent either at the next meeting or the meeting thereafter. And then Mr. Thompson and our chief counsel or whoever's in her stead can have that discussion at that time. And then we can expound and build on whatever we want to do. And as far as whatever action the board would like to take.
Very good.
Okay.
Do we have a second?
All right.
Any more discussion? Okay, all in favor?
Aye.
Opposed? Motion carries. Thank you.
Okay, case number 2, complaint number 202-400-2531. Respondent submitted certificates for 24 hours of PDH for September 2023 renewal. After review, only 16 hours were within the renewal period. As per rule, no PDH are rolled over to the next renewal period, making the respondent deficient of 8 hours. Respondent subsequently provided more than 8 hours to become compliant. The recommendation was to send a letter of warning and pass the laws and rules exam.
Is there a discussion? Do we have a motion?
Second.
All in favor?
Aye.
Opposed? Motion carries.
That's good, Melanie. We've learned our lesson. We're doing the discussion on the front end instead of the back end, that's good.
Case number 3, 202-400-5621. Complainant states that their employer firm failed to disclose the responsible charge retired in July 2023 and did not replace the position or file a firm disclosure. Research online shows a press release that responsible charge retired June 30th, 2023, and remained as a part-time employee and advisor. Complainant has recently obtained an engineer license on February 28th, 2024, and filed a firm disclosure on February 29th, 2024, stating them as the responsible charge. The company has merged into a PLLC on February 23rd, 2024, with delayed date of April 1st, 2024. The former company has closed, but there was a firm disclosure on file since 2016 with a retired part-time advisor as responsible charge. Close is the recommendation.
Is there a discussion?
I would like to move that we close this case.
Second.
All in favor?
Aye.
All opposed? Motion carries.
Case number 4, 202-306-3751. Earlier in the year, complainant responded to 2 requests for qualifications issued by the state. Complainant was ranked first for both RFQ responses and was awarded one of the projects. As part of an internal lessons learned process, complainant has a practice of requesting copies of competitor submissions and of reviewer score sheets for any state projects, regardless of whether awarded or not, and did so with each of these projects. Complainant received copies of the competitor's submissions. With respondents' responses to the RFQ for both of the projects, each submission listed multiple projects that were, in fact, completed by complainant, including 2 of the 5 featured projects in each submission. According to the complainant, respondent was not a member of the design team or involved in any way for these listed projects. While respondent submissions correctly acknowledged the engineering and landscape architecture consultants who worked on certain projects, they did not correctly acknowledge that complainant was the architect of record and sole designer for the projects listed. Respondent listed 24 total projects that are of similar scope to the state projects that were marketed. 7 of the 24 projects were completed by complainant, not by respondent. In their response to these requests for qualifications, respondent used written descriptions, renderings, and photographs that appear to be illegally copied or downloaded from complainant's website, which is copyrighted. Within respondent submissions, the marketing descriptions used for the state's projects were copied word for word from complainant's website. Complainant alleges violations of acceptance of work, public statements, and misconduct. Let me take a Respondent denies the allegations and understood that the project list and the request for qualifications can include projects from the proposing firm or its consultants. Respondent clearly stated that the projects listed include projects from respondent and consultants collectively. Respondent's consultants worked with complainant on some projects listed, but do not believe the respondent violated any rules by including the consultant's projects on the project list, as they were following the guidelines of the RFQ solicitation documents. Further, a sampling of our design team's collective similar experiences listed below. The design team is commonly used and understood as the designer and its consultants combined in the A&E industry. Respondent believes that the proposal is clear that the 24 listed projects are respondent and consultants' work. Since those projects were included for the consultant's experience, respondent did not specify the architect of record. The renderings, photographs, written descriptions, and questions on the project sheets that respondent included for the consultant's project experience, and the contents were submitted to respondent by respondent's consultants for their project experience. These projects happen to be collaborative works of the consultants and complainant. Respondent did not download information from complainant's website. Respondent confirmed that the project information was provided by the consultants to feature in the projects. After review, it was determined that the complaint stems from how one interprets the information requested by Section B2 on the request for qualifications issued by the state. It is unclear who is right or wrong in their interpretation, so the information appears ambiguous. What is clear is when a project is presented in proposal, all designers should be credited, not just the consultants for the project that might be a member of the proposer's design team. According to Rule 0120-02-.06, if a registrant uses visual representations of prior projects or experience, all registrants whose seal appears on the plan specifications and or contract documents must be clearly identified. In reviewing the information presented, it appears that the respondent is in violation of this portion of the rule. This portion of the rules should supersede any interpretation or misinterpretation of the RFQ, since all registrants must be clearly identified. The other allegations do not seem to warrant any penalty based on the ambiguity of the RFQ. So the recommendation was to authorize a civil penalty of $500 by consent order and formal charges for not clearly identifying all registrants whose seal appears on the plans and require that they pass the laws and rules exam.
Discussion?
The respondent is an architect. It's an architect with a firm.
I move we accept the recommendation.
Second. Any further discussion?
I have a question. So, if I'm interpreting this correctly, it looks like there wasn't any intention at impropriety. It's they simply did not annotate correctly all of the appropriate people that should have been given credit. Is that correct?
That's right.
Okay.
So we'll vote on the motion.
Yeah.
All in favor?
A little bit of an explanation. There was a the TBR put out this RFP, and it had a section B2.2 that was ambiguous. It can be interpreted different ways. And the one that the respondent, and the way the respondent interpreted was they could show a project done by another architect, but they were using the same consultants that the respondents was proposing for this project. And so they used the consultant's information. And so the other side of it was, they were saying, hey, that's our job and we don't see our name anywhere. And that's the reason for the recommendation is that, notwithstanding whether it was ambiguous or not, our rules say you have to name everybody on if you're marketing or proposing something, you have to name the architect on the firm, for example. So that's what this is.
So does the, excuse me, the motion stand? Okay, so we have a motion and we have a second. And all in favor?
Aye.
All opposed? Motion carries.
Case number 5, this is complaint number 202-400-7141. Respondent self-reported that they mistakenly failed to renew their license when it expired January 31st, 2023. Respondent realized their mistake on January 31st, 2024 when they attempted to renew their license and found it had expired. Respondent communicated this to the board via telephone and email February 1st, 2024. Respondent has since reapplied and had their license reinstated. During this time when the license was lapsed, the respondent provided engineering and stamp drawings for 19 projects without realizing their license was inactive. The respondent stresses this mistake was unintentional but entirely their responsibility. I had recommended that we send a letter of caution, but it seems like usually you guys send a letter of warning and pass the laws and rules exam.
There's also a civil penalty involved for each of the times he used his seal, that they used their seal, should say.
Okay. So what would be, I asked, I did speak with the engineer and they, asking them if they could send me a list of the projects they worked on. And I guess they had been out of office because they didn't receive the email, and they responded to Chris and I this morning saying that they would get together a list of those projects and send it to us, but they did already say it was 19. So I suggested a letter of caution or a letter of warning, mostly just because the facts to me indicated that this clearly was a mistake, but based on some of the other cases, we can amend that.
I would say that we have a lot of precedents for exactly this same thing. And I would recommend that we use the same precedent that we've used in the past with just the determination about what the civil penalty per each seal, each time they use their seal would be.
So wait, let me just say, let's do letter of warning. Do you require they pass the laws and rules exam usually in this scenario? Okay. And then you want a civil penalty?
Yeah, that's probably fair. I don't know I don't think any of us have seen what the work was. So we don't know whether it's a really detailed set of plans that would, for buildings of public occupancy.
So would that impact your decision? Would you prefer to wait until we have a list of the projects?
I think in the determination of the assessment of the civil penalty, that's usually how we weigh or make that determination is what the complexity or the potential health threat to the public health and safety is. If they were just signing letters or writing reports, that's a little bit different than preparing full plans and specifications.
They were just working at their full capacity since it was, clearly it was like the exact date the following year that they usually renew. I imagine they were not holding back on their work because I truly don't think they realized what they did.
I'm sorry, is this an engineer or an architect? It's an engineer. I would recommend that you forward it to an engineer for review to let them make a determination about the severity of the use of the seal. And maybe defer this to the next, I can't make a motion, obviously, but defer it to the next meeting.
I will make that motion to delay this until next time where we have more information, assuming that the parties involved get the information to legal and then for an engineer to review.
Laura, you did say that they had contacted you and they were going to provide you with that information.
Yeah, so Chris and I reached out to them last week, and I think unfortunately they were just out of the office, probably on vacation with family or something. That's what they made it sound like, and said, so this morning they responded and said that they would get together a list of those projects for us. So I am assuming we'll get those fairly quickly, and I can send that to someone to review.
We have a motion on the table, and do we have a second
I'll second that.
discussion?
Just for a reminder, previously on these types of cases, the penalty has been anywhere from $250 to $500 per occurrence. So we have 19 projects that someone needs to take a look at and say, if it was a letter versus whatever scope of a building, whatever, I mean, that's a year's worth of work that someone didn't pay attention to their licensure. And I agree with you, Alton. Thank you, Alton. So just.
Is there any consideration for when someone self-reports?
No. Well, it's a mitigating factor, but it's still what it is.
Mm-hmm. Okay.
That's why it's 250 to 500.
That's always a mitigating factor. But again, it depends on the severity of the offense, whether it was something that actually has the potential to affect public health and safety versus just a letter or something less offensive.
You can try now if you want to talk. A few folks came off. It can only be 4 at a time. So if you look around and you count 4 mics and somebody just turn it off and then we're good to go.
Enough said.
Did we vote then? It sounds like we had a motion on the floor for a laws and rules exam, letter of warning, and then a represent rather with that might be where we're driving, but a represent. Okay. Yes, sir.
Yeah. One other comment is if they provide you with the list of projects, scope of the work would be beneficial. So we would know what they did, basically. Yeah.
And the recommendation was to send it to somebody on the engineering committee to review, to let them make that determination.
So we've got a motion and a second from what I perceived for a represent and a review by one of our board members. Then we'll just need all in favor.
Aye.
Aye.
Any opposed? All right, hearing none. That one is passed.
Okay. Case number 6, this is complaint number 202-400-7221. Respondent self-reported that their certificate of authority in North Carolina is suspended in December 2023 due to tax-related issues. Because the certificate of authority was suspended, so was their engineer license. The firm reports that they worked with accountants and the issue has been resolved and the license was reinstated in March 2024. And the recommendation was to send a letter of caution.
Do we have discussion?
I have a question. I'd like to, you reviewed this, right? Did they perform any work during that period of time?
They did.
So did they prepared documents or plans, specifications, or whatever else?
Well, not in North Carolina.
Did they do anything in Tennessee?
I got clarity on that.
Eddie, just need your, sorry.
More than the professional engineering license. It was the certificate of authority and not a suspension of an engineering license.
Well, the suspension was in North Carolina.
Right.
There's nothing in Tennessee.
Right.
But if they were suspended in North Carolina, So was their engineering license, correct? So if their engineering license was suspended for that, what, 3-month to 4-month period, depending on when it occurred, I guess the question would be, did they practice or stamp any or seal anything on a project in Tennessee? That would accompany a civil penalty.
Why would that matter?
I'm not,
Because
If
it's
they
still,
don't, if they're not licensed, if whoever, is it a firm license? Because it's an individual license,
a
right?
certificate of authority for a firm license, not an individual license.
And
Okay.
they were not in violation of any rules in Tennessee. They were just it's an issue in North Carolina and it got resolved.
I think I followed up a question with Stuart because I had a question if this came up, sending a letter of caution, or even if there were a penalty, would it go to the firm or would it go to the registrant in charge? And he said it would go to the registrant in charge, but I see this as a company certificate of authority and not an individual license.
And
No violation in Tennessee.
No violated.
for matter of precedent, we regularly do send letters of caution for other jurisdictional issues. Unless there's something here, we don't typically sort of nail them down, for that. But those are, so that would be wholly consistent with the recommendation coming from Stuart. I could see him doing, I can't speak for him, he's not here, but, just, we all know.
Yeah, I also, there was no suspension of the Tennessee license. It was the North Carolina license, just to clarify.
That clears that up. Thank you.
Do we have a motion?
So moved.
Second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
Okay. Case number 7, complaint number 202-401-4301. Complainant alleges respondent is advertising architect and architectural services and does not have a licensed architect or is not a licensed architect. It is visible on their physical signs and in digital advertising. Respondent states that they only work on projects that are less than 3 stories and less than 5,000 square feet per the exemption. Any projects that are not exempt are for the local licensed architects. So the recommendation was to authorize a civil penalty of $1,000 by consent order and authorize formal charges for using the name architecture on social media and website. Also order the respondent to remove appellations from all social media and website. I'm sorry. That was the recommendation.
We have a discussion, a motion.
So moved.
Second?
second.
All in favor?
I,
Opposed? Oh,
Could I ask, I'm sorry.
yes.
This person is not a licensed architect.
Correct.
Is that correct?
Correct.
We have no jurisdiction over that as a board, correct?
We have jurisdiction over their unlicensed activity.
Right, but we can't do anything other than fine them and then they can fight that. So just making sure everybody remembers that. So, yeah, okay, sorry.
Okay, we have voted. Do we have opposed votes? Motion carries.
Did you have something to say? Okay. Case number 8, complaint number 202-401-7611. Respondent self-reported that they had practiced on an expired license. The license expired on June 30th, 2023. Respondent states that they have been taking care of their spouse who is going through back surgeries and recovery, and that's why they failed to renew. Respondent stamped plans on 2 projects during the expired time. However, these projects were small residential renovations that were both less than 5,000 square feet, and therefore they were exempt. The recommendation was to send a letter of caution and ask them to pass the laws and rules exam.
Do we have a discussion?
I move we approve the motion.
Second?
second.
All in favor?
Aye.
Opposed? Motion carries.
Case number 9, complaint number 202-401-5921. Respondent apparently self-reported that they had practiced on an expired license. However, the respondent states they misunderstood the question. Respondent's current position with TVA is a power utilization engineer, and then that does not require a PE license. Since the previous license expired, respondent has not performed any electrical engineering work that required a PE license. Recommendation to close complaint.
Discussion? Do we have a motion? Second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
Okay. Case number 10, complaint number 202-402-0131. Apparently self-reported that they had practiced on an expired license when they went to renew in June 2023. However, respondent states they misunderstood the question and mistakenly checked yes. Respondent was practicing, but under direct supervision of a licensed engineer at their employment. Recommendation to close.
Do we have discussion? Motion? Second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
Case number 11, complaint number 202-402-4551. Respondent self-reported providing services while license was expired. Respondent stated they have continued to be employed at a facility that does not require a PE, nor does their position. Respondent mistakenly checked yes to the question. Respondent further states that they do not offer engineering services at the facility where they are employed, but rather research advisory services. Recommendation to close.
Discussion?
I move to close.
Second?
Second.
All in favor? Opposed? Motion carries.
Case number 12, complaint number 202-402-5541. Respondent submitted certificates for 24 hours of PDH for September 2023 registration renewal. After review, only 5 hours were within the renewal period. As per rule, no PDH are rolled over to the next renewal period, making respondent deficient 16 hours. Respondent states during the last period for retaining PDH, he was diagnosed with cancer and has been traveling to Texas to receive care ever since. During recovery, respondent was placed on reduced hours and pay until October 2023. Respondent is trying to complete the 16 hours as fast as possible to be compliant. Recommendation, send a letter of warning.
Discussion? Motion?
I move we send a letter of warning.
Second?
Second.
All in favor?
Aye.
Opposed? Motion carries.
Just a comment that we don't have rollover hours anymore. So that we should probably let that person know that you can't use a rollover. So just as a courtesy.
Right.
Madam Chairman, in the previous case that we had on this agenda that had the same, we also asked that they pass the laws and rules exam. I was wondering if we should add that to this as well.
Would we like to amend the motion?
I would like to amend the motion to include taking the laws and rules and passing the laws and rules exam.
Okay. So we'll revote. All in favor? Does the second of the previous motion apply?
It's basically a new motion, so
Okay.
probably need a second on that one. Since
My
we're,
second.
all right, we got a second from Ms. Thompson. All right.
All in favor?
Aye.
Opposed? Motion carries. Thank you.
Okay, so the last two complaints on the legal report are representations. So this is case number 13-202-3025-121. I'll probably just read the new information if that's okay. This was a case that previously the board was authorizing a civil penalty of $2,000 by consent order and formal charges authorized for advertising engineering services without being registered, and to direct the respondent to remove all engineering designations from their website. So here's the new information. This matter has encouraged thorough conversations with respondent's attorney and the use of appellate appellations. Respondent believes that all the instances referenced in the consent order and complaint, when viewed in context and not in isolation, clearly demonstrates the limited use of the term engineering is in relation to design build projects with engineering services being performed by respondent's partners with elite engineers, not the respondent. Respondent asserts that Tennessee does not have an absolute ban on the use of the term engineering. An unreasonable, strict interpretation of these statutes would prevent an EIT from using engineering training appellation because it uses the term engineer with a qualifying adjective. According to respondent, such a prohibition was clearly not the intent that this section in context is everything. There are many situations where these statutes do not require registration. For instance, TCA 62-2-103 sets forth at least 6 different exemptions to any such requirement. This is in addition to the lack of applicability of the statutes on any federal project or for services in which registration is not required. Example, value engineering, industrial engineering, nuclear engineering, biomedical engineering, chemical engineering, aerospace engineering, etc. Section 62-2-102 sets forth several other exemptions to the registrant requirement. Earlier, respondent mentioned that its use of the appellations were in relation to design build projects. The board has a policy regarding design build contractors. As respondent believes they fall under this policy, it states contractors without in-house registrants offering design build services are in no way authorized to perform actual architectural engineering or landscape architectural services. Such professional services must be performed by duly qualified registrants in conformity with the provisions of TCA 62-2-101. Contractors may offer design build services to the public without having to comply with the firm disclosure and supervision requirements of TCA, I should say 62-6-601, provided no architectural engineering or landscape architectural services are offered in-house. Further, respondent claims that they follow the policy by offering design build services by organizing the design team comprised of Tennessee registered engineers competent in the work to be performed prior to the time services are formally proposed. Additionally, these engineers are involved in any activity in preparation for or leading to a signed contract. The new recommendation was to close.
Discussion?
I've got one question. In the original complaint, that it was said that the respondents was advertising in-house engineering. Now, is this the case or is this not the case?
Again, there we go. In addition to that, at the bottom, it also says that they claim that the respondent has more than 20 years of averaged experience for designing to engineering and complete installation of electrical systems. So not only do they say in-house engineering, but they say they've got more than 20 years experience with those in-house engineers.
Further discussion?
Was it Rob's recommendation to close this? He reviewed it initially.
I believe that was Stuart's recommendation. I think the conversations, from what I could gather when I was reading through the files, is basically that the respondent is, no work is being done by anybody who is not registered to do the work, and that when people, like clients, come to this firm or to this business where they offer these design and build services, but it seems like they're collaborating with the registered engineers.
But they're claiming they have it in-house, not that they're collaborating. And that's false. They don't have licensed professionals, quote, in-house, let alone licensed professionals with 20 years of experience. So they're using the appellation engineer without having a licensed engineer.
Mm-hmm.
Correct. Yeah, that's right.
I think that what they're doing, it's a subcontracting sort of issue. So it's they're stretching that scope, but there's I think that's kind of where they're at. And so since they didn't necessarily fall under since they under the code, that hence the recommendation, or hence the conversation that.
And I disagree with the recommendation. I think they clearly are in the scope. I think they clearly are violating using the appellation without having a licensed professional on staff.
Yeah, it didn't say 20 years or something to that. You know, it said 20 years average experience.
Design, engineering, and complete installation. They're claiming responsibility. All phases, not just installation. If that's on their experience.
Just chat, if everyone could check their mics, just, yeah, we want to get that on record so we can, because that recording, and if it's not on, we won't hear it.
Say it again. I just wanted to point out under their experience on the original claim, it says they have more than 20 years of average experience from designing to engineering and complete installation of electrical systems, which means they're claiming all aspects, not just the subcontracting portion.
Next sentence too.
Yeah, and our personnel managers, electricians, electrical engineers, I don't know. I think there's an issue there.
Yeah.
Would someone like to make a motion?
This, if I may,
Should we?
I find this
Sorry.
really confusing. And maybe because I'm not an electrical engineer or whatever, but I also wonder if this doesn't fall under the 5,000 square feet rule, where if they're providing these services on large facilities, would that make a difference in this discussion as well?
I think the issue was the advertising, so, yeah.
Yeah.
Right. And I'll let, obviously, Miss Martin here may jump in, but since Rob Barrick will probably be in attendance at the next meeting, we could certainly, punt it till that meeting so you could get a little bit more, we could flesh it out a little more if you want to get into it.
But I guess as a matter of procedure, there's already been a motion and decision approved that's still out there, correct?
Yes.
The board decision of authorizing a civil penalty of $2,000 by consent order and so on, that still stands?
That still stands. This was a case that Stuart wanted to bring before the board again, because after having these conversations, he felt like, maybe they had fallen within the board's policy and they weren't totally inappropriately using these terms. We can move forward with the decision, or we can wait to hear what Mr. Barrick has to say, since he did review this complaint.
Could you explain a second what in the new information is being referred to when it says it's somehow different when reviewed in context and not isolation? What does that mean?
I think the respondent's attorney was encouraging us to look at the whole website and see that they're not trying to pass themselves off as an engineering firm. In context, they're saying that if you are a client of ours, here are the services that are going to be provided to you, because they are partnering with people that can provide the services that they are not qualified to give.
So what they're trying to say now is, yes, they're advertising in-house engineering, but they have more information that says they're not. Is that what I'm hearing? It says they're.
If that's the case, why not just take in-house engineering off? That's what we're asking them to do.
Yeah, it shouldn't be there.
Yeah.
At this point, I'd like to stick with our decision from the last meeting, board decision.
I second that motion.
All in favor?
Aye.
Opposed? Motion carries.
The last case on the legal report, case number 14, this is complaint number 202-303-5981. So again, this is a long case, and so I was just going to read the additional information, but as a recap, respondent is an engineer who was contracted by the complainant to work on an RV park, and it seems that there has been a lot of back and forth because the city had certain requirements that they had to meet. The complainant says that the respondent has done bad work, has done incompetent work, and also taken very long to get work done. And there's just been a lot of back and forth on this. And this is the most recent information I had. And then I thought we could have a conversation about it and come up with a recommendation. So the new information is respondent's attorney sent additional information regarding this case. During the time this complaint has been active, the complainant has continued to work with the respondent and use their services. They allege that the reason for most of the allegations made by complainant are because of the 19 change orders that have been requested by the complainant to date. Allegedly, each time they requested the changes, the respondent would send the proposed new plans to the complainant, and these were for quick review and not intended to be submitted for approval. It seems when plans have been submitted, they were approved. Respondent also alleges that many of these change orders were attempts to remove or relocate the manholes the city required, meaning they requested changes that would have made the plans not compliant with city codes. Regarding the check, so previously it was alleged that the complainant had given the respondent a check to pay for TDEC for a permit, and the respondent changed the check because TDEC had changed the way that they accept money at the time. And so the respondent was attempting to get this permit paid when probably they should have voided the check and directed the complainant to apply for the permit.
That's not exactly correct. When he got the check, he changed it from TDEC to his own name to cash it, so that he could write the check to TDEC. When he did that, after he did that, he found out that TDEC no longer accepted checks, that you had to do it by credit card. So he did that prior to knowing that they only accepted credit.
Right. I don't think that the respondent is saying that that's what happened. The respondent is saying that they did that because they were attempting to pay the TDEC and did not realize that they had changed it. Probably not great, regardless. But I will say they did submit the receipt showing that they did pay that permit fee to TDEC for $1,000. So I was hoping that Mr. Heathcote could help us with this a little bit, since he clearly has reviewed this complaint quite a bit. So there have been errors on the plans that we've had a chance to review. And the respondent is basically saying, every time I've submitted these plans, they have been accepted. So their argument is
which is not accurate
accurate
either.
Okay. Would you like to talk about this complaint?
I sure would, and thank you. And I should apologize, and Laura, I sent you an email this morning in response to your email from yesterday about why I took it on myself to hire someone to review these plans. And the reason I did that is twofold. One is because the individual that I hired has 40 years of experience in review of subdivisions, these types of subdivisions. I don't have all of the expertise that he has. But the second is to differentiate or separate myself and not allow any introduction of bias into the review process. I have encountered this individual in our role representing municipal clients for subdivision submittals that he's made that have been similar to this set of drawings, and have taken numerous attempts, and finally us having to design components of it in order to get through the approval process. There's a there's an absolute demonstration of incompetence and multiple review sets. The latest one being, I think, the September of 2022 review set, which I think the community still had issues with. There are still outstanding issues, and the approval was contingent on correction of those errors. So, and many of these, and I'm gonna lay it out there. When Stuart sent this back to me with the new, the not the June, but the September drawings, the latest drawings, I gave it back to the same guy to review again. And I'm going to pay him for the review of that set of plans. I'm full disclosure. But there are more than 6 pages of comments on his latest set of plans that are wrong. That would dramatically impact the integrity of this project, the retaining walls that RVs would run into, slopes that were wrong, detentions in the wrong place. There's any number of things that are terribly wrong with this design, and it demonstrates abject incompetence. Even if you do forget about the fact that he altered the check and put his name on it, there are significant issues with his quote completed set of plans that the owner approved. There are, and I know I personally think Stuart was nervous because this individual hired an attorney to help represent him. And I understand why he did. The appeal is that this would affect his livelihood. It would ruin his business, which I understand that. And I don't think Stuart wanted to take that severe an action to suspend his license. There are other, and I made a separate recommendation to you if we weren't willing to go to that length under our other enforcement actions under the civil penalty section, 120-02-.10, other enforcement actions, item 3 says assignment of a probationary period with peer review of all technical work accompanied by reporting requirements from the reviewer. If this board is not willing or doesn't or feels that the suspension of the license is too severe, then I would offer that as an alternative, less severe, but at least this board and whoever its designated reviewer would be would have the opportunity to oversee any submittals that this individual makes in the future to ensure that other submittals like this one don't occur again.
I think that is an appropriate recommendation that we can talk about.
I do have another question.
Well, I just want to address the other part of this issue. We have to go through our own contract processes with CPO, Central Procurement Office, and this board does have access to expert reviewers, and then the board can pay for those. And I just don't think it should be an expectation that you guys pay for any of that out of pocket, but I can appreciate why you were attempting to cure any bias that you thought you might have brought to the case. But I think it does it is a little complicated. But I think that's an appropriate recommendation for peer review if that's something that the board wants to discuss. That's all. So did you have anything to add, Glenn?
I have a question to Alton. This is a simple question. Does what this guy has done, is it detriment to health, safety, and welfare?
No question. Yes.
I think the respondent's argument, so I'm not arguing against at all that there were errors in the plans. That is something that Alton found and pointed out to us. I think the respondent's argument that a lot of this has been aggravated by the complainant. Basically, in their words, not mine, the complainant has consistently asked for change orders only to then say, no, I don't want that change order as soon as they realize that, something may or may not cost more money. And there's also been a lot of argument because I don't think the complainant really I don't think the complainant is really thrilled about some of the things that are required by the city. And so I think that the respondent's argument is that these two factors that are in control of the complainant have really aggravated this situation. So that I think is what the respondent was trying to convey to us.
And I think that's convenient to the respondent and not wholly accurate. I have seen the reviewing agency's comments. They're legitimate comments.
Mm-hmm.
And the fact that he didn't like them or didn't want to comply with them is irrelevant. They are their codes. They are their requirements. They're their subdivision regulations. So he should have known that going in. They are specifically designed also to protect the integrity of their
Unless I'm misunderstanding, I don't think the respondent was the one that had issues with the city's code compliance. The respondent's argument is that the complainant has continually pushed them
and he is
put
a
aside
licensed
the city code compliance.
He's a licensed professional.
Mm-hmm.
He can't, then he has an obligation to tell his client, I can't do that. I'm not going to do that. And in this particular case, it doesn't appear, this was his design. And his design was fraught with errors that would affect the public's health and safety. They clearly demonstrate incompetence in design. And again, we have clients that aren't engineers that clearly don't understand the rules and regulations of the guidelines associated with design. And they ask us questions or request different things. And we clearly tell them, no, here's how this happens. Here's what the design criteria are. Here's how we have to do this. And that's our responsibility and obligation, not only to ourselves, but also to them, to help protect them. And in this case, I think that's a weak sister excuse for not doing the right thing.
Mr. Thompson?
If we move forward with our consultants that do the review work for the state, would it be appropriate, since this appears to be very complicated, and thank you, Alton, for your review comments, but I think it might be beneficial to the board if we can defer this to one of our consultants that the state would pay for review to have that other opinion, and it would be more clearly delineated from the state's perspective, from the board's perspective, if that's acceptable to the board. And again, no offense to you, I just want to put that line in there that it's actually coming from one of our consultants.
And as a comment, I agree with what Rick is recommending. I also don't think it's fair for one of the board members to be out there enlisting another consulting firm. So I think that the state doing this is really the way to go. I don't think this needs to be on his back. This needs to be on the board's back. So let's allow the state to review the set of plans, and whether when I submit a set of plans to the city, state, whomever, I should know what the rules are and what the regulations say that I should and should not do. And an independent consultant reviewing the set of plans will be able to discern that. So then we have two recommendations by independent sources.
Mr. Jett?
Yeah, I just have a procedural question beyond the say for instance, you have a finding that the engineers found incompetent. Does the board have the authority to vote to revoke the license and send this person back through a process of re-licensure, or what does that look like
Yeah, so if the board makes a finding, but if the board determines based on the evidence presented to them that this person is incompetent, revocation is part of the discipline that the board is entitled to impose. But it, of course, that would still follow, the normal process by the UAPA. So that would probably start out as a consent order where they could choose to just agree all the way up to a hearing where we would have to call witnesses who have reviewed the work.
So as a follow-up, does if it's by consent, so does the board really have the authority to vote to cease practicing engineering until this is resolved, or practicing architecture engineering until this is resolved, or does that go along live with, you see what I'm asking? I mean, is there?
We cannot stop someone, how do I phrase it? We cannot take somebody's license without going through due process. So there are mechanisms in place where you can sort of summarily suspend a license for a short period of time. It's an extremely high bar to meet to do that. We call it a summary suspension, and I've seen it happen very rarely, and it's usually like very malicious activity involved.
Yeah.
But any discipline that we impose is going to have to come, and even that summary suspension, that's not permanent. And because again, the idea is that we still have to come back and go through due process. So the board could vote to send a consent order asking them to agree to suspend their license for a certain amount of time. There's a lot of things, there's a lot of different ways to put together a consent order. But at the end of the day, it's by consent. They would have to agree to it. And if they didn't agree to it, to impose it, we would have to go forward with a hearing.
Are the other enforcement actions by consent as well?
Yes. So that's why we always ask for a civil penalty by consent order with authority to with authority to file formal charges. So the idea is that if I'm an engineer, I do something inappropriate, the board decides I've done something inappropriate, they're going to send me a consent order and say, okay, here's the evidence we have that you acted inappropriately. Here are the rules or laws or whatever we think you violated. And we're going to take you to hearing. We're going to take you to court over this. Or you can settle, it's basically a settlement, but we call it a consent order because we do require that they, that they agree that they violated the law and they sign and say, yes, I did this. I'm going to pay my civil penalty in lieu of going forward with a hearing. Does that explain the process?
Yeah,
Okay.
so technically you could go to this individual and say, by consent order, you will lose your license, and you can go back through the process of passing the PE, providing references again,
Mm-hmm.
or we
not.
can take this to hearing and you can get it revoked and lose it forever. Is that a pretty good?
But isn't it still revocation, the first option?
It is, and we have precedent for that.
Yeah.
It's still a revocation.
It is, yes.
But you could, I've seen revocation go forward where the board says we're going to revoke you and you can come back in 1 year's time and reapply, or, there's.
But we have taken action. It was a permanent revocation.
Yes. But to what he's saying, it would still be a revocation, but with maybe some direction of like, we will reconsider your application and at whatever later date.
I do have another question. To my knowledge, and I may be wrong, I'm asking the question, does the state have consultants on call for this type of review? I'm not aware of that.
So, Glenn, do you want to answer that?
We contract expert reviews. We can do that. And I haven't, we haven't had to use them a lot because we have a lot of experts right here,
That was my exact
Yeah.
thought. If we've got people that you hand this to review these.
And it's been very beneficial to use a lot of our associate engineers because they don't necessarily would have to recuse themselves because they don't have the vote, and so that's helpful. That's really helpful to use them.
And I am an associate engineer and I don't have
Right. But yes, we do have expert reviewers on contract. We just, I'm gonna have to dust that file off probably, but, and then where there wasn't, we would just do a, a requisition or a, forget what they call it. But we could get one. It's not that, not that.
I have a concern about that. Mainly because I know most of the civil engineers, at least in this town, that perform those services. And I would want to make sure that whoever the state selected to review this had the requisite experience, knowledge, expertise to be able to do that, not just somebody that responded to a state
Oh, no, it's
solicitation for services.
robust. It's very robust. I've sat in a lot of those, that selection process. And there's a criteria, and it's not like entry level criteria. There's certain level of demonstrated competencies in there and their background. I mean, the references, and they have to speak to each point of that contract to be able to qualify.
I think my point is that the firms that are actively practicing that are really good at what they do don't respond to state solicitations to do reviews. They're actually doing their own design work, and they're completely busy doing that.
In other words, do
Is
we
there
have
somebody else on the
say
board that
in
can review that
selecting
doesn't know
that
them personally?
consultant?
Yeah, that's the bottom line. That's the question.
And we could go with another associate engineer. I mean, we could pass it on to, well, these poor guys that's in there with that target looking at them. We'll let y'all thumb wrestle for it.
I would gladly accept their review. Any of the members of this board, I'd gladly accept their review.
Alton, what about the individuals that you have hired?
There's only one.
Okay.
And he works with me on, we perform subdivision reviews for a number of our clients. I do the utility component of those reviews.
Mm-hmm.
He does the site grading, storm drainage, pavement, curb gutter, et cetera. And he worked in a firm, a large firm, local firm, and who does a significant amount. That's their primary business is subdivision development.
Mm-hmm.
They are the civil engineers on subdivisions, commercial, industrial, and significant residential. So he has, I think, 17 years of that and 23 years for a large metropolitan city in reviewing subdivisions that were submitted to that city.
Is there a way that review, that documentation can be utilized by this board?
It was, in the sense that it was, it informed our first reviewer. We do already have, we've already made a decision on that, and we've already sent it for executive review, or excuse me, expert review. And so at that time, we could then, if we're still not pleased with what we have, then we could pass it on to another board member review. But I think we've already got it in process, and we're moved that one. And then, so we're gonna get to see it again anyway. Once we'll get some more of that information, we can, so unless there's anything else to add to it, I think that was the last one on the legal report.
But in the meantime, this individual gets to continue to practice.
I do wonder, I mean, not to be confusing here, but Robert Campbell may be a past board member who understands our rules and what have you. And I believe this is what he does for a living. I wonder if utilizing him in this situation wouldn't be a good source for us.
I probably should have deferred this complaint until the next meeting. There was just so much information, and I knew that Alton had already reviewed it, so I felt like it deserved some board consideration. I have worked with Robert Campbell before, so you're right, he would be a good reviewer. We just want to make sure that if we're moving forward with a case, that we feel confident, right, that we have all of the proper witnesses and evidence and all of that stuff if we're going to move forward with a case, which is probably what made Stuart nervous. And of course, when there's an attorney on the other side, really keeps you on your toes, but that doesn't mean that that changes our decision about how we're going to move forward. So, like Glenn said, we're going to send this for expert review. And then maybe we'll talk about getting an additional review in addition to Alton's review. And then I'll have a chance to have a more thorough conversation, and we can come up with a better path forward at the next meeting.
Laura, I don't think I sent you this second set of review comments on the latest, on the most recent set that he provided. I'll send those to you.
That would be helpful, yeah.
Okay.
And if that's the case, then I think we should definitely push this for one more meeting, at least.
Do you think we can get, contract with Robert Campbell and get his information back to us before the next meeting? The reason I asked that, this looks like it's been going on since November of last year or something like that.
And I think Alton would like to see some kind of action.
Yeah, I'm really concerned about the quality of the product this individual is putting out there, and I think it has a definitive potential for negatively affecting the public's health and safety.
Mm-hmm.
And apparently he's continuing on.
Yes.
That is my concern, Frank. You're right.
Let me explore the expert reviewer that we already have a contract with and see if that would be appropriate. Because that would probably be quicker than anything else. And if that's not the case, then we can send it to one of our other associate engineers.
Laura, just, and again, I know that the state probably has vetted this person, but I'd really like for you to send whatever their resume or their qualifications are to some member of the engineering committee, at least, to let them look at it and say, you know what, yeah, these people are eminently qualified.
Okay.
We have a motion. We do not have a second. Do you want to retract your motion, or do you want to revise your motion?
I didn't make a motion.
Somebody made a motion about.
I thought
Was it
Blair
me?
made
I
a
think it was.
I'm not sure we made a motion. I
Okay.
agreed with Rick. I
Okay.
liked his comment, and so,
Okay. So
but
we
I
don't
don't
have
recall
a
that we had a
motion.
motion.
Okay. All right. Good.
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 Alexandria?
Could,
I don't think we
could,
have one on the floor.
could staff offer a motion about, you
I can
conferring
offer a
with our
motion.
existing
Yeah,
consultants?
I would prefer to defer this case for now, and with the board directing staff to consider other review avenues, including the expert we have in file, our associate engineers, and then also Mr. Campbell.
Do we have a second?
Well, not to mess up the works, but we made a decision at the last meeting and apparently voted on it. And then we've got new information, but the new information I see says that the respondent was making changes that the complainant asked for, and they're trying to say that that shouldn't have, that's a reason for them to do something wrong. I mean, that's the way I'm reading it. And so I don't see that the new information is mitigating anything.
My point exactly. It continues, and there is no substantiation that anything's changed or different. And from the review of the latest set of plans, that's validated. There is no difference. There's still not a good set of plans.
So if we don't take any action, does the decision of the previous board meeting,
Yes.
it's in effect? I'd like for it to stay that way. So
Here.
Has the direction from the last board decision, has there been action on that?
No,
With
there's not
the-
yet
so
been
there's been
action
no
on that.
There's been no
Um,
communication to this individual about a voluntary suspension yet?
I'm sure that Stuart told and also this is public record, I'm sure that the respondent's attorney was aware that that was the board's decision, and that's why they started sending additional information. So I'm sure that is what prompted these conversations.
Another question. Alton, you had mentioned that with our charge, safe and healthy welfare of the public, a suggestion of at some point having his current work outside of this specific project reviewed for a period of time. I don't know if you specified for a particular period of time, but since this seems to be ongoing, is there a desire to have a requirement in place to review other work while the board is determining, since it's potentially pretty egregious that he could be suspended permanently, is there a desire to have his ongoing work now reviewed in the meantime?
Yes.
Okay.
That was why I offered that second alternative.
We cannot do that without him consenting to it or them consenting to it.
That was why I offered it as a second alternative.
Okay, I was just wanted to bring.
So that we could get at least some resolution to this and be able to ensure that anything he did beyond right now, at least we could have somebody competent to look at and determine, wait a minute, is this safe? Is this something that we can approve?
So in the legal report, I'm not sure exactly when this decision was made, but new information, the first report of new information, the board made a decision, authorized the voluntary suspension of respondent's license for 6 months with all projects to cease and desist after the suspension, authorized probation for 6 months with a list of all work to be reviewed by the board by consent order and formal charges. The board will randomly select at least 3 projects for expert review and present to the board during the probationary period. Further, the respondent shall take and pass the laws and rules exam.
That was
that
the
was from
previous
the
decision of the board,
previous
yes.
decision.
And that is currently the one that still stands.
So
That
no-
was the previous decision of the board?
Yes.
Okay.
So no action has been taken on that decision.
I believe that decision that has been communicated, and that's why we have received additional information of the respondent saying that this is they presented additional information in response to that board decision.
This new information, I don't see anything that would actually affect all of the things. Sitting through this new information, not really new information.
Correct. I agree. So do we find new information to be applicable to the board decision that was made at the last meeting? So probably at the end of the day, our discussion is that we would like to continue with the original board decision being made that was made at the previous board meeting.
And you wouldn't need any action because you already took action.
Yeah.
And so they would just, if you did nothing, then it would just stand. And then we get a response from them. They either sign the consent order or they go to a formal hearing.
Okay.
Question. Do we report, does the state of Tennessee report this information to any other states in regard to violations? Because I know architecturally that information gets out there and you are in jeopardy of your licensure in other states. I'm not sure if if it's exactly when
After, like,
if the
once
consent
it's-
order has to be signed first or not, but
The
I know
consent
that,
order would have to be signed, or you would have to go through formal charges, but then at that point, I guess it's through NCWS. They
Okay.
do report across.
across the board.
Yes.
I know that it occurs with NCARB,
Mhm.
is that if you are convicted of a violation or fined or whatever, then that's knowledge that every other state gets.
Yes.
Yeah, okay, so, I mean, that's some jeopardy that they are in, is my point. Unless they're not licensed anywhere else, it won't matter, so.
Strong possibility. It's a very, very, very small firm.
Yes.
For more clarification. So currently, this board made a decision at a previous meeting. That is still in place. However, the respondent's attorney sends information to the board, so we've now delayed any action on that decision, correct? So notice none has been made. Does that make sense?
I don't want to say that no action has happened because this is sort of just part of the settlement process. Yes, it's been delayed because the decision was made to bring it back to the board and share the information that the respondent's attorney shared with us. But from my perspective as an attorney, that doesn't mean no work is being done on this case. It just means that there was enough information that Stuart, and I agreed, wanted to present this back to the board. And I wish I had had more time to talk with Alton about the case, but I did the best I could. So that's where I'm at. So that was just information that I felt like you guys should share. But again, it's not as if you guys made a decision and nothing happened. You made a decision. That decision was shared with the respondent's attorney, and this is all part of attempted settlement negotiations.
So as our attorney, we don't need to reaffirm that previous
You don't need
decision
to reaffirm
with a
it. You
formal
can
vote.
just,
Okay.
you can very informally, as you are doing now, tell me we'd like to stand with our. Seems that there's no motion, so it seems that the board would like to stand with their original decision. It's,
A quick comment. Would it be diligent for us, while this, it sounds like this is a conversation with their attorney, but would it be diligent of the board to go ahead and request the previous 6 months of work or a list of submitted to us by a certain date? That way we could keep that process moving at the same time. So that while we're procuring an
request
expert.
it, but to require it, that is considered discipline.
But I guess I'm stating that we're requesting the previous 6 months of work because there was a problem with this recent project.
Mm-hmm.
And if we do move forward in any hearing, all that comes back to, if there's nothing wrong with your work, then why wouldn't you submit it for the board to review? We were just being diligent to say whether this was a one-off or, because that's kind of what we're making the recommendation of getting the past work and hiring a third party to review it so that we could see those comments.
Just couldn't require it, so, yeah. No.
We can request it.
Mr. Wagster.
I'm assuming when we make a decision like this, that the respondent has a certain amount of time they're supposed to respond,
Yes.
and they can't continue to respond with new information and dragging on forever. So their response, I guess, needs to be said that they either agree with it or they don't, and we go to a formal hearing if they don't. Is that correct?
Mm-hmm. Yes.
What time did they have to respond?
Do they have to respond to us at least? I think we give them like between 30 and 60 days to respond. But for a case to go from settlement to a filed notice of hearing and charges, I mean, that usually takes a little bit longer. There's certainly a preference to settle cases more than there is to go to a hearing, but that doesn't mean we won't. It just means that we're still in that process, but we can move forward on this. I think to move forward on this, I am going to request some additional review of the work.
Could I make a motion?
Yes.
I'd like to make a motion that we stand with our previous decision, that we've reviewed their additional information, and we need to move on. We have a motion. Oh, I'm sorry.
Habit.
All in favor?
Aye.
All opposed? Motion carries.
Thank you. And thank you for your patience with me, picking this up and moving through your process. I appreciate it. Thank you.
Thank you, Laura. I appreciate that too. Kind of being thrown into it, and it's so complex and, with that sort of level of complexity to be able to enter into that thread and that stream, I think that was, speaks to her experience and, her competence. So, and none of it, we know that, but you guys haven't had to experience that. And so, thank you, Laura.
And Laura, I personally too want to thank you. You had two really tough issues on this agenda that we don't generally have. And man, you got thrown into the viper pit, and thank you for what you've done to prepare for this.
And I second that emotion.
It goes in the minutes now. Great. Did you have anything else, Laura? Okay. And that, I think we're ready for new business then.
Do we have any new business to discuss? There be no further business. This meeting is adjourned.
Thank you very much.
Thank you, everyone.
Thank you.
Hey, Glenn, you have to escort us upstairs, right?
You actually, those of you that have these, you can go anywhere you want, but they'll let.
But we don't know.